I know. I'll be nice.
I don't see Mr. Gravely here, do we?
He was with me just now. I don't know what he. Right here.
Good afternoon, ladies and gentlemen. All right. Good afternoon, ladies and gentlemen. If everyone would go ahead and have a seat. And if you would, go ahead and check your cell phones to be sure they're on silent or vibrate if you want to thrill. I welcome everybody to the House Public Safety Homeland Security regular committee meeting today. We've got several bills in front of us. First off, we're going to call on Chairman John Yates. Chairman Yates has House Bill 123 that had left this committee, went to the Rules Committee. At the request of several of the members of the Rules, there seemed to have been a flaw, and it was recommitted back to this committee, and we now have some information as far as how to clean up the intent of the bill. Chairman Yates.
Thank you, Mr. Chairman. Members of the committee, this started out, Mrs. Fletcher came to my office, and I guess that looked like a friendly face or whatever. I don't know why she came to me. And told me that her daughter had been killed when a trailer broke away from a pickup truck and went across the road and ran into the vehicle that her daughter was driving and killed her. So it seemed like to me something ought to be done, and I remembered that there is a better way. When I worked for Ford Motor Company in Denver, Colorado, I had a camper trailer weighed about 850 pounds, and they had a law there that you had to have a chain to go from one vehicle to the other to restrain it. And I used that for several years, and it worked fine to restrain so that the vehicle didn't part from the other one. So I put in this bill, and originally, of course, there's been a few changes since then. I think maybe the original was LC 390857, and then I think after one of the meetings they came along with this other change, LC 390939S, and then the latest thing is they got an amendment, AM 390093.
All righty. Thank you, Chairman Yates. Chairman Jaspers, you've worked with Chairman Yates on this.
Yes, sir.
And this language, I believe, is what came from the Transportation Committee Chairman.
Yes, sir, Chairman Roberts.
There had been some concerns at Farm Bureau, and them had some concerns at the end, even though they had signed off on the bill as it originally passed this committee. They realized there might have been some other problems with that language. Could you maybe address this?
They feel very confident that the amendment that's been provided will answer those questions. You know, the Chapter 2 are those vehicles that are required to have a tag, and this will, they're just very clear that it just limits those non-tagged trailers that are farm trailers from this. There's low speed, you know, hauling cotton, peanuts, that sort of thing, from farm to farm or farm to buying point.
Do we have anybody from the Farm Bureau here today?
Yes, sir. Chairman Powell.
Would you like to just come up and just give a quick comment from y'all, since y'all had some, we'd reached out at first, now we're back again. Have y'all looked at this language now?
Yes, we're good with it. Yes, sir.
So this creates no problems for our agricultural community?
Correct. Thank you. We appreciate Representative Jaspers and Chairman Yates as well.
Thank you, sir. All right, any questions from any of the committee members? Number 26, who would that be?
That's an accident, Mr. Chairman. My book was on the button.
All right. Any questions from any of the committee members? All right, do we have anyone out here anybody in attendance that wishes to be heard on this? All right, number 29, who is that?
It's me, Mr.
Mr.
Chairman.
Atwood.
I just want to praise Chairman Yates for this. We had this exact same situation happen in my district on the causeway going to St. Simon's. A trailer broke loose and unfortunately killed a young lady that I'd worked with. So I praise you for bringing this forward. So.
Very good. Any other comments from anyone? All right, what's the
Move to pass.
as a committee substitute? All right, we have a motion do pass as a committee substitute, and you'll have the amendment AM 390093 in front of you. We have a motion. We have a second. Any further discussion? Nothing else. All in favor say aye. Aye. Opposed? The ayes clearly have it. Thank you, Chairman Yates.
Thank you, Mr. Chairman, ladies and gentlemen.
Next up, we have House Bill 455. That bill belongs to Chairman Wilkinson, and he has asked Chairman Jaspers to be kind enough to steer that through the committee. You can certainly do it right there.
Okay, thank you, Mr. Chairman. This is House Bill 455. If you look in your file, it's LC 410469S. It's a real simple bill. Let me find it. Oh, there it is. Take a second and read it. This is going to be a long read. But as you read, I'll just talk a little bit about it. Chairman Wilkinson, is ill a little bit, and in the afternoons he needs to go home, and asked us to help him with this. Pretty simple thing. It gives the Department of Transportation, if you look in that code section, the authority to close a highway in state of emergency or for public safety reasons. You look down on line 11, it's C, and it really gives some exceptions, and that's for towed vehicles or towing vehicles to and from those areas. And we're adding a really key group to be able, so that they can give the transportation can give them authority to allow them in these areas, and that's to persons delivering medications to pharmacies and hospitals. I think we'd all agree that that's an important duty that we would like to see happen. It obviously has been stopped at some point, and we're just trying to make sure that happens. And it's just a very quick amendment to this little code section, Mr. Chairman.
Any questions from any of the committee members? Do we have anyone here that wishes to address this bill or the amended version? None. Number 26. Yes, sir.
Question, Representative Jaspers. Would hospitals include skilled nursing facilities?
I don't know if that's in definition, Representative. In hospitals, it could be a good add.
Might be a good
I think
addition.
most pharmacies deliver to nursing homes and skilled facilities, don't they?
They do, yeah. They use institutional pharmacies typically, so they usually have delivery trucks as well. It would be an addition. Now, oftentimes they're really considered skilled hospitals, in a sense, but I don't know precisely whether that definition would catch it or not, but it might be good to include them, if not.
Mr. Chairman, I don't see that would hurt if it's please the committee to.
And I think that hospital personnel, emergency personnel, I think they're already exempt. But we need to check it to see. But
I'd be agreeable if you'd like to make that an amendment to this to add skilled nursing to that.
I think that that hospital personnel are already exempt.
Okay.
Or what I'd recommend, check if you would. We need to move forward with this because time is getting of the essence. If you want to check to see, we can always do it as a Rules Committee amendment.
I'm good with that, Mr. Chairman.
All right. What's the will of the Mr. Atwood?
Mr. Chairman, also possibly there might be, with any amendment later on, added the definition, a clear definition. I'm not sure if it's in statute on the nursing facility. May or may not be. If not, they need to cite it back to that definition.
Yes, sir. All right, what's the will of the committee?
Recommend do pass.
We have a motion, we have a second. Do we have any other discussion, any other comments? If not, all in favor say aye.
Aye.
Opposed? Ayes clearly have it. Don't have Julius here today, do we? I might recommend Chairman Jaspers ask Julius, he's not in attendance today. I don't think he is.
I know we had another committee meeting.
You might want to ask Julius to check to see if those other categories would be exempt.
Yes, sir.
All right. House Bill 93.
Thank you, Mr. Chairman, members of the committee. Today I'm bringing you House Bill 93, and the LC we're working off of is LC 410460S.
Go right ahead.
We'll start out with a quote from Benjamin Franklin. "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." This bill strictly addresses license plate readers. If anybody has passed a law enforcement vehicle or cruiser lately, you'll notice there's a camera on the front and often on the rear of the vehicle, and that is a camera which is able to take around 1,000 pictures of passing vehicles, and it scans their license plates, and it checks against GCIC records to see if there's any outstanding violations. Before LPRs were in use, officers would literally be on the side of the road writing down the license plate numbers of the cars that would pass. They would then input these plate numbers into the GCIC terminal, often in their vehicle, and if there was a violation associated with that particular plate number, it would throw up a flag, and then they would, of course, pull the vehicle over and do what they had to do. License plate readers automated that procedure. So the intent was just that, to allow law enforcement to check more cars for outstanding violations of the law. With that respect, this bill changes nothing of the original intended use of license plate readers. License plate readers can still be used. They can still check against the GCIC database, and they can still keep the license plate data of people who are suspected of a crime or involved in pending investigations. And those are not subject to any sort of window of how long they can keep the data. And they can also still contract with a third party to store the data gathered from these license plate readers. None of that changes in this bill. What this bill does do is it sets a purge policy of 90 days from the original collection of the data. So if Representative Petrie is driving home to Savannah down 16 and he passes by a Georgia State Patrol vehicle and he's not suspected of anything, after 90 days from the moment that data is captured, if he's not suspected or charged with any crime, that data is purged. If Representative Gravely is suspected of a crime, I'm not insinuating anything, if you pass by a GSP and your tag number is flagged, it's then associated with a case number in the GCIC database. Until that investigation is listed as no longer pending, they are able to keep your whereabouts in their database. It is a $5,000 fine for violating that law. Now, what that means is if I'm a law enforcement officer and I want to see where my wife has been, I can't just go willy-nilly into the system and find out where her car has been spotted. So it also requires that local law enforcement has a policy in place for use and operation of license plate readers. And of course, as I said, it says that the standard GCIC auditing procedures still apply. And also, more importantly, it exempts license plate reader data from open records requests. Under current law, if I were to go to the Columbus Police Department and do an open records request for my wife's vehicle or anybody's vehicle whose license plate number I know, I could find out exactly where they've been. That's important to note because as this technology becomes more and more affordable, you're going to see more and more of these license plate readers. They can be mounted underneath bridges, mounted to light posts, mounted to every police cruiser. And again, this is a good law enforcement tool to catch bad guys. But what this bill does is addresses how it's used in relation to people that have never been convicted of a crime or even suspected of a crime. We've worked with law enforcement for the past 2 months to try to find some common ground. Originally, the date range was 30 days. We've tripled that up to 90 days. We've got favorable reactions from both the GBI and the ACLU. We've excluded data related to the Georgia Tollway Authority. They can exempt their use because the drivers using the lanes of the toll authority, they're entering into a contract, and it's a civil violation for unpaid tolls. There was the Dalton newspaper wrote an article this past weekend. Murray County Sheriff's Office, according to this article, now has a 7-day purge policy, and they only keep the data that produces an alert in the system. Now, about a month ago, I got to sit in a car with the Harris County Sheriff's Department, and we were right on 185, and we would see all the cars come by, and every time it picks something up, you see the picture flash up there, and it gets this beep. Well, when somebody comes by with an expired tag or insurance has lapsed, I mean, it's quite literally sirens go off, and you can. There's no confusion as to if it's flagged or not. Whitfield County Sheriff's Department says that they have a formal written policy of a 90-day purges, which is identical to this bill. So right now, there's no uniform policy for purging data in the state of Georgia. Some agencies collecting upwards of 500,000 images per week. Now, the image, every time it scans a plate, it gets a full image of the car and then a close-up image of the license plate. And so included in that is the GPS coordinates of where that car is, and it's time-stamped. And we're still talking about less than 1,000th of 1% of these images actually result in an alert, if that makes sense. Give you some perspective. Minnesota currently has a 48-hour purge policy. The state of Virginia was actually debating a 24-hour purge policy. It's my understanding, according to testimony in the last subcommittee hearing, that law enforcement has worked with Virginia to up that to 90 days, which coincidentally is exactly where we stand today. This is a 90-day purge policy. I feel very strongly about the 90-day purge policy. Now, there are some that will argue that the policy should be anywhere from 5 years to no limit whatsoever. I have a problem saying that if you've never been suspected of a crime, that there should be no limit as to how long your government can keep data of your whereabouts. One more thing, and I feel like I'm getting long-winded, but if there is cross-agency sharing of this license plate data, the data still must be purged within 90 days, once again, of the original collection date. Information collected by third parties must be stored immediately and may not be shared unless it is for law enforcement purposes. So private companies cannot sell their databases of this information to law enforcement. Companies who use the information for their personal company will not be prohibited from doing so, but they just cannot sell it or share it. That is the gist of the bill, and I will be more than happy to answer any questions from the committee.
Yes, sir.
Thank you, Mr. Chairman, and I know you've worked very, very hard on this, and I've actually signed off on it with you. And you just asked my question about the 90 days, and you did compromise from 30 to 90 days. My question was, if you transfer this data to another agency, would the clock start over? And you just answered that question and said it would be purged in 90 days.
90 days from the original
So
collection.
where is that in the bill?
Let me find the line number. Line 33, all such data collected shall be destroyed no later than 90 days after such data was originally collected, unless it is the subject matter of a toll violation or law enforcement purpose.
There you go.
Yep.
That's it. Ms. Taylor?
Thank you, Mr. Chairman, and thank you to my seatmate.
Thank you.
This is a great bill. I had one question that I want to make sure I've gotten the answer correct. If this information is used in some type of a prosecution, would there be a problem if it is deleted and somebody is then later tied to an offense or a crime and maybe they didn't know it was that person and it's gone? I really didn't think about it until you said there's an image of the car.
Right.
What if there were two people in the car and they don't discover this person committed the crime for a while? I mean, and it's gone. That crossed my mind. Is there a problem with that?
So I want to be clear about the question. So if there's a suspected violation with, we'll use my vehicle,
Okay.
and it's being investigated. If it's being investigated, there is a case number attached. It's married to that image.
Okay.
So as it goes throughout the investigation process, there is no purge policy. That data can be kept on file as long as necessary until that case is closed.
Okay. What if they don't suspect you yet? They haven't found out you're the one. I mean, and maybe you said I was on a different road at that time,
Right.
and now it's 120 days, and they can't retrieve that to prove you were on the. I'm just asking. That
Sure.
crossed my mind. I worry very much about having everybody's private data
Sure.
and where you are and tracking. It doesn't feel comfortable at all. But and thinking about that and saying, well, it's an image of a car. What if you were looking for who was in that vehicle with you? And they haven't found the criminal. Maybe
Right.
they don't know the crime you committed.
Well, I wanted to be clear. You can't see who was in the vehicle with you.
Okay.
It's not.
It's just the vehicle
It's
itself.
just the vehicle itself.
Okay.
Yes, ma'am.
Okay, thank you.
Any other questions, any of the committee members? And I think that at the end of that, where it says, or law enforcement purpose, that would even, I think, not being an attorney, but I would say that even if there was an ongoing prosecution or a trial, that would still, for that purpose, would still be, these files would be available throughout.
That is
the court
correct, Mr.
proceedings.
Chairman. Yes.
All right. Any questions from anyone? Any other committee? Do we have anyone out here who wishes to testify? Anyone wishes to be heard on this bill? Number 27, who would that be? Mr. Hitchens.
My concern is if you have an ongoing investigation, somebody has been identified and the law enforcement agencies looking at them, would we still, because that's very often early in the process, 90 days, would we be able to retain that information because the trial, certainly we all know in today's society, when you have serious criminal offenses, they don't get tried for a year or two.
All right. All right, do we have anyone else? Do we have anyone here that wishes to be heard? Would you like to step up here and identify yourself?
Chairman Powell, members of the House Public Safety and Homeland Security Committee, my name is Thomas Weaver. I'm a private citizen in North Georgia and the Cherokee County area. I rise today in support of this legislative proposal, House Bill 93, as proffered by Representative Weasel. The 13th paragraph core amendment of Section 1 of Article 1 of the Georgia Constitution and the 4th Amendment of the United States Federal Constitution guarantee my person to be free from unreasonable searches and seizures. And it is a collateral consequence of 21st century technology that our forefathers never could envision or maybe couldn't fully understand the full impacts electronics and technological devices. And as our technology advances, I venture to say that this legislative body is going to continue to run into similar situations in future legislative sessions when there are different issues that involve technology. I respectfully ask this committee's favorable consideration in hopes from the Senate that we pass recommendation on this proposal to shield Georgians from the abuse or misuse of continued data mining of citizens absent of any reasonable articulable suspicion or probable cause linking that person or that person's behavior or whereabouts to criminal activity. When the better half of 99% and then some are not suspected of crimes, law enforcement has no business to continue to track or scan and monitor that person's activities and whereabouts.
Thank you, Thomas. Number 27 down there again.
It just didn't get cut off, huh?
All right. All right. Number 23. That'd be Mr. Jaspers.
Yeah, thank you, Mr. Chairman. This committee, our subcommittee A, has heard this bill twice, and for Representative Pizzold, I just wanted to brag on him. I was teasing him earlier today that look at what he started with 3 or 4 weeks ago, what he has today. Just wanted to, it was a good lesson, and working in public safety, and I just appreciate all the hard work he's done and the folks around him, and just concentrating on this, and I sure appreciate it.
And I certainly appreciate your comments. Number 24.
I know there was a concern earlier addressed about some pending investigations taking a year or two, and it was my understanding, I just want to make sure I'm clear, that the bill as written currently, if there is an ongoing investigation with, and that person's vehicle is been tagged with that case number, it will not be purged, and that the law enforcement can keep that data for prosecution purposes.
Absolutely, that's correct.
Okay.
Thank you.
All right. And then I believe Ms. Frazier.
Yes, thank you, Mr. Chairman. Just
ma'am.
curious, this is a good piece of legislation, but I'm just curious, how does this, with all the data being collected, how does this work when we get Amber Alerts?
This has zero effect on Amber Alerts. That still applies. If an Amber Alert pops up, it will still be flagged.
Okay, so you know when they do the Amber Alerts, and I know all the data that's collected in these police vehicles. Is this a tool that they use to possibly solve one of these crimes?
Yes.
Because all the thousands of cars that are passing by,
Yes.
those license plates has to be, yeah.
Well, and that's why we have the 90-day purge policy. Now, I certainly don't have data on Amber Alerts, and
Yeah, just
but yes, if it's flagged, then and it's a part of an investigation, then there is no purge policy. If it's an open
okay.
investigation.
All right, thank you.
Thank you.
Very good. And I believe Mr. Lunston.
Yes, we've had this discussion, and I still don't think I have a good answer for this or a clear answer for this. But say, for instance, you have a crime committed. The person who committed the crime flees the area. Maybe their image is captured by one of these several counties away.
Sure.
The person is not identified beyond that 90-day period. The course of the investigation is such that that person is not identified or their vehicle is not identified
Yes.
until beyond that 90 days. Yet with your 90-day limit, that image that was captured that may be very instrumental in helping to solve the crime is no longer available. It wasn't flagged because it wasn't known until beyond the 90-day period.
I would argue that evidence is still circumstantial. And if the case hinges on whether someone was on a highway at a certain point in time, I don't know that that's going to be the straw that breaks the camel's back on a case.
Certainly the case, it would be a case-by-case basis, but to outright say it's just circumstantial, I think, is a little bit of a stretch.
Thank you.
Do we have any other questions? Last chance, Sundance. Anybody else out there want to be heard? Since brevity is normally a rule, and I think this one's past that point. Good bill. What's the pleasure of the committee? You're recognized for a motion.
Thank you, Mr. Chairman. I'd like to make a motion to pass.
As a committee substitute.
Apologize, Mr. Chairman, as a committee substitute.
All right, we have a motion to pass of the committee substitute. Do we have a second?
Second.
We have a second. Do we have any other questions from any of the committee members? If not, all in favor say aye. Aye. Any opposed?
No.
A no? 2 noes. We have 2 noes, and the ayes clearly have it. This is on to the Rules Committee.
Thank you, Mr. Chairman.
Thank you for your interest in this. Now, just as a matter of something you might want to lay awake and sleep on at night, think about all of those record services out there that are running these tag readers. Every time you see a record traveling the highways and the byways of Metro, they're clicking everybody's tag and they're selling them out there in perpetuity. That ought to give you a lot to think about besides laying next to your wife.
Church would give me part of it.
All right.
And I'm sure if the Secret Service hadn't been in proximity,
Go right ahead.
and they went back and they rental agreements. And,
Let's see, House Bill, I saw Mr. Nimmer back there, I do believe. And do we also have Mr. David Clark in here today? Would you mind bowing to the senior member? He's not much, he's not much senior, but you know, if you don't mind, come on up, Chad. House Bill 421, Mr. Nimmer. I believe this will qualify for the governor's bill, wouldn't it?
Yes, sir. A name change. Cool, y'all, is it that late in the day? This is dealing with disability allowances for those involved in the parole officers and State Board of Pardons and Paroles and Department of Correction probation officers. You know, we seek to merge those two together and form one Department of Community Supervision. This is just cleanup language, provided that goes forward, to make sure that we don't have any disparities with any allowances owed to any employees.
All right. Any questions from the committee members? There's not even a substitute for this, is there?
No, sir.
And that's a shocker.
Try to be efficient, Mr. Chairman.
I believe this would almost be a companion bill to the to 310, isn't it? This sort of fills in the gaps of those officers that are being moved to the new Department of Community Supervision.
Yes, sir. Yes, sir.
Excuse me. All right. Do we have anyone that has any comments? I see someone from the parole board. If you would, Ms. Rocker, please come up and join us. Thank you for being here.
Thank you for
If there's
having
any
us.
committee members who didn't know Miss Rita Rocker, you do need to get to know her because she can tell you all about your constituents that is waiting in the prison somewhere.
Might be more than you all want to know. On behalf of the parole board, we just wanted to be sure that those post-certified officers who remain under the employment of the parole board, and some will, they too are covered under, under disability, or that those benefits remain with them also. So just wanted to be sure that this bill would do that.
Well, has your attorneys over at Parole Board, have they looked at this to
Yes,
script?
sir. I've submitted some proposed language. We have some proposed language that our attorney, you want to?
Yeah, and we're trying to get that drafted, sir, Mr. Chairman, and get the amendments offered in. If you want to, Mr. Chairman, I'll bring them to you if you or the committee wants to offer it as an amendment here during committee.
You've seen the language
Yes,
that
sir,
he's
I have.
got?
Yes, sir, I have.
And y'all, the governor's office, has looked at it and they're in agreement to that?
At this time, yes, sir, we are.
Would this also mean the same scenario for those employees that are still left over at the Department of Corrections? Would it affect any of those people too, the same way some of the parole board members?
I believe, yes, sir, if I understand your question right, it takes care of making sure that nobody gets caught in a gap anywhere, those that stay in existing employment positions or move into the new board that is being formed, or the new department being formed.
Do y'all have the language with you?
Yes, sir, sure do.
I want to suspend, I'm going to use the prerogative of the chair, I want to suspend action on this bill for right now.
Okay.
If the two of you might could get with committee counsel Julius.
Okay. Sure.
Go and work with Julius on this. Tell him exactly what y'all want and let that legal mind look it over, and then let him prepare a substitute, because I really don't want to bring y'all back in another meeting. I'd like to move y'all's bill forward.
Thank you, Mr. Chairman. Appreciate that.
All right. I'm going to suspend action on this, if y'all can get with Julius and work up your substitute for that. All right. Mr. Clark.
Thank you, Chairman and committee members. Today I bring before you House Bill 278, LC 213728S, and you should have on your desk is the substitute to House Bill 278, and it's the exact as the original. Just the only thing I added was more time for the Safety and Fire Commissioner to have more time to prepare to take over this task. Back in 2012, the Georgia Department of Labor handed over to the Office of Insurance and Safety Fire Commissioner the safety and inspection duties, and the only thing they did not hand over was the Public Employee Hazardous Chemical Protection Rights to Know Act of 1998. And so it's just transferring it from the Department of Labor to the Department of Safety Fire Commissioner. And also the Department of Labor just does not have the resources to handle this job. So I'm just thinking it's just a smart choice to bring it over to the Safety and Fire Commissioner. And I talked to the Commissioner of Insurance, Ralph Hudgens, and y'all should have letters from both departments saying that they both know of what I'm doing, and they're both in support of it. And just to go over the bill, it's pretty much exactly what it was in the Department of Labor, and I'll quickly go over it to explain it. In Section 1, it's just transfers the responsibilities relating to the hazardous chemical protection, such as training and creating notices and regulations, from the Department of Labor to the Office of Insurance and Safety Fire Commissioner by changing the definition of the department to the Office of Insurance and Fire Safety Commissioner. And then also you see in Section 1, line 90 through 92, and why that's cut out is just these labeling requirements, are unnecessary, such as the warnings, and because the warnings are required under other Georgia and federal rules and regulations. So it's just extra stuff that does not need to be in there. Over in Section 2, it's just it's the repeals subsection. It's just relating to exclusions from labeling requirements and dissemination of information. And again, this is just these labeling requirements are unnecessary, as such warnings are required under other Georgia and federal rules and regulations. In Section 3, this is just shifting. It's just talking about shifting from the responsibilities to the Department of Insurance, and no longer is it the Governor's Employment and Training Council, which they had over in the Department of Labor. So it's just cleaning up a lot of stuff that does not need to be there anymore.
I might ask a question, David. Basically, what you're doing is you're shifting this right to know program from the Labor Department over to this State Insurance Commissioner's office.
Yes, Chairman.
And both departments are in agreement to it?
Yes, Chairman.
And I see that the Labor Department has even brought their most famous faceless bureaucrat, Mr. Tim Mitchell, who was once upon the picture of the faceless Democrats of America over at the Department of Revenue before he went over to the Labor Department. And is he here to basically testify in favor of this? Tim, would you stand up and introduce yourself to our friends here?
Thank you. Yes, we support it.
Good bill, isn't it?
Yes, sir.
And it's got a good author.
Yes, sir, it does.
And you've been working with him hand in glove to be sure that everything is correct.
Yes, sir, and so has the Commissioner of Insurance Office.
Very good. All right, committee, do we have any questions about this bill? We have a substitute. Mac?
Thank you, Mr. Chairman. Just one question. Will employees go over from one department to another or just the duties?
No, just the duties.
No shifting of employees?
No shifting of employees. Any other questions?
Any questions from it? Let's see, that'd be Mr. Hitchens down there?
That's not me.
No? Who's number 28?
Lights won't go off.
All right. Now it's off. All right, do we have any questions from any of the other committee members? Do we have anyone else that wants to testify or to give any feelings of just a bearing desire to talk about this issue? All right, if not, we have a substitute, LC 213728S, in front of you. What's the will of the committee?
Move to pass.
We have a motion to pass as a committee substitute. We have a second. Now, do we have any other questions? Nothing else? All in favor say aye. Aye. Opposed? Ayes clearly have it. Thank you, Representative. Good job.
Thank you, Chairman. Thank you to the committee.
All right. Mr. Nemmer, are you back? Are we all ready now? Not yet? Have a seat.
Yes, sir.
All right. Mr. Gravely, do you want to try yours next?
Yes, sir.
All right. For number 492.
494.
Excuse me, 494.
Mr. Chairman, if I may, I'll sit here, but if I may invite Ken Vance, Executive Director of the Georgia Peace Officers Standards Training Council, and Mr. Mike Powell with the Law Enforcement Education Organization up, please, sir.
Mighty good to have all these old gray hairs here today. Mr. Vance, good to see you.
Good to see you, sir.
Mr. Chairman, House Bill 494 is currently under construction as of the last 2 minutes by Mr. Julius Talbert as well. But since we are in a, I guess, holding pattern in the committee right now, if you'd like, I can explain what we're doing here in just this paragraph.
Please do.
Yes, sir. Currently under House Resolution 218, U.S. Congress passed a couple years ago, it allows a retired law enforcement officer to continue to conceal carry after they have retired. One condition of that is that they qualify annually with the particular weapon that they are going to be concealing. Oftentimes the officer will qualify with a revolver and a semi-automatic. They may want to carry their .357 and their 9mm. What this bill seeks to do is take that, if the officer decides to qualify at the same time with both their revolver and their semi-automatic, then the charge for the printing cost, the mailing of the permit, or I guess the card that says they have qualified, would just be $25. Currently, they have to have a $25 fee for the revolver qualification and the semi-automatic qualification. What we're proposing is if they do that at the same time, they mail it in at the same time, they can have both revolver/semi-automatic printed on the card, and that should just be a one-time annual fee of $25. If they choose to qualify at separate times with their revolver and their semi-automatic and send those qualification papers in separately, then they would have to pay the $25 charge for the revolver and the $25 charge for the semi-automatic. We would like to do that if they choose to do it at the same time. They would just have one $25 charge. So we're taking it as the bill states, without any payment. We do recognize the cost, and I believe Mr. Vance and Mr. Powell have worked out an amicable situation to where they've agreed upon to cover the cost of printing, mailing, any follow-up that Post would incur. That $25 cost, if it's done together, would just be a one-time annual fee. And Julius is, I believe, second in line. This bill is after the governor's bill. Will be worked on to reflect that language.
All right. Question, if I may.
Yes,
Under
sir.
this, you say that they're allowed to carry 2 weapons? Are they permitted for 2 weapons, or could it be more than 2 weapons?
It could be, well, if I may defer to Mr. Vance, Mr. Powell, Mr. Chairman.
Sure.
At the present time, the way it's stated is you can qualify with a semi being a 9, a 40, a 45, and they would issue a card for a semi-automatic, which means you could carry any semi-automatic that you
So it doesn't have
possess.
to specify
Right,
the
it doesn't
caliber
specify
of
the weapon.
make.
It just says semi-automatic. But if I also want to carry my 38 Special or my 357 at a separate time, depending on what I'm wearing, or if it's summer or winter and I want to carry a bigger or smaller gun, I might have a small revolver. I would have, at the present time, I would have to pay Post $50 a year to qualify with both weapons, even though all they do is print semi/revolver on the card. What we've agreed to is if I send in my certification that I qualify with my revolver and my semi at the same time to Post, they'll only charge me one charge of $25. As of now, they're charging me $50 to send me one card with 2 words on it. But if I qualify with my semi-automatic in January and then I decide to qualify with my revolver in August, I filed separately, so therefore there would be a charge of $25 each time.
Now, you
So
say
we've
this is all allowable under the federal firearms licensing?
Yes, sir. This fee has nothing to do with the federal government. All this is.
So then, all right, I want to take it to another, because it's bringing into another issue I'd like to think about. But these cards, these would basically stand just like my concealed weapon permit would stand. So that means a retired officer that has this card can use that when they go to a weapons store. And they
Not
can
for purchasing.
Not for purchasing.
Just for carrying. So 99% of us carry that card and a concealed weapons permit like I do. I carry a concealed weapons permit that I purchased through the state so that when I buy a gun, I don't have to go through the background. And I carry this because this gives me the right to carry as a police officer, whereas the permit that you would get only gives you the right to carry as a civilian, and there's different areas and different laws that cover
So
that.
the card that we're looking at right now that's issued by Post,
Yes, sir.
that would not stand as a background card to buy a weapon.
No, sir.
So these officers, retired or active, would still have to have a
Gun permit.
gun permit.
Or go through the process.
We'll go through the background filing process. So this has nothing to do with the state gun permit. This just gives me or another officer that's retired the right to still carry as I did when I was a police officer.
This is a pretty cut and dry, pretty simple proposition, what the representatives got in front of us.
Yes, sir.
Now, could we complicate this any by, for the benefit of these officers, retired and, quote, active, is there a possibility these cards could be made active for use, to be able to use as a identification to buy a weapon?
No, sir.
Cannot, because of federal statutes on the Brady Act.
This is just your right to carry, not the right to purchase. This has nothing to do with Georgia state law under the Carry Act. This is just under the federal law, the Law Enforcement Safety Act that Bush signed into law in 2004, and then in 2010, Obama clarified the language as retired, what a retired officer was, and that's the only thing it's doing.
Very good. Well, I understand my own philosophy about brevity, and I've said enough. All right. Mr. Radley, anything else you want to add to this?
I believe that, Mr. Chairman, I'm just going to wait for Mr. Julius to get the language, and I see he's with the governor's floor leader at this moment, so I'll continue to wait.
All right. Do we have any of the members want to ask any questions, have any comments or questions while while he's waiting on council to get this finalized. All right, if not, then at the prerogative of the chair, I'm going to hold this bill in line for the council. We're fixing to move to the next one. All right.
Thank you again, sir.
Mighty good seeing you guys. Ken. All right, we've done 278. Beg your pardon? All right, we've done 278. Number 492.
Chairman, I'll come down here so I can see everybody's face. I'm sure he'll have a question. First, I'll start off. Representative Hitchens started off, said, another gun bill. I said, no, sir, this isn't a gun bill. This is a little different. This is a follow-up on House Bill 60. I think main thing we sure know in this bill is you haven't gotten hundreds of emails and the room's not standing wall to wall with people. And so, but the House Bill 492, I really want to just start off thanking the Probate Judges Council, Mark Middleton behind me here, Georgia Carey, of course, always kind of looking over my shoulder, helping me, my local probate judge, magistrate court judges in my area that we sit down and kind of work all this through with, just addressing questions from House Bill 60. These bills are complex. You start out with something real simple, but I'm just going to kind of go through it. Because I know if I do it now, I'll answer the questions that'll come up. But I just, and we'll kind of go through it section by section just to make sure we're all on the same page. We'll start on section 1. Once you look down and see on line 19 and 20, you should be on LC 41040S. It is a sub. You'll see this written 3 times in here. There was some concern with different departments within the state that when we passed House Bill 60, we undid the code section 1611-130. And this 1611-130 is the list of exceptions that's out there. Just like we just heard about Representative Gravely's bill on the exception of law enforcement to go certain places. There were some people thought that this 60 undid 130. We don't agree. But we put this in here in 3 places to answer it. And I hope you'll see that I've just been so congenial to try to answer all these questions. But that's why it's there. Section 2, we'll keep moving. Now this is in, and I'll just go 1611-127. This is carrying in unauthorized locations. And you look on line 25 as the first change. And this is a clarification. You know, and I want you to read this and read along with me as I say it. You know, and unfortunately, we didn't print the whole code section for you, just little bits and pieces to save paper. But in line 25, it'll say that you cannot carry a weapon in a government building as a non-licensed holder. And in that part of the section, there are 7 different areas where you can't carry as a non-licensed holder. And so it's real clear, you know, like in a courthouse, you know, you can't carry in a jail, blah, blah, blah. But that first one is as a non-licensed holder. Because remember in 60, we allowed the carrying in a government building of someone with a license. And the only time it's prohibited is when there's active security at the government door. And which this is to clear it up, because out in the communities, they thought anybody could carry in a government building. We're stopping that. Line 26 is on number 7. Within 150 feet of any polling place, and we're adding when an elections are being conducted and such polling place is being used as a polling place as provided in section 27, blah, blah. Okay, this was where we found, folks, there's lots of different buildings that are used as polling places. There are churches, government buildings of all sorts. So we really defined it that is an off-limits area during election time, absolutely staying with the 150 feet. It's just clearing it. And then again, you see the next line, the 29, 30, just like we looked in section 1. We're not undoing anything. Section 3 and 4, the same thing. This is in school safety zones. We're not changing anything in 130 there. We're not changing anything in section 4 and how it affects nuclear power plants. We didn't want to have this question for citizens out there. If you look in number 5, this is where we start with the probate judge issues. Very fair to us this summer, just bringing up issues. Rick, I got a nice letter from them just spelling out these are the questions, please clarify them. They're very respectful and very helpful too in trying to say, let's figure this out for the citizens, because none of us want a citizen going in to renew their weapons carry license and have a question in the probate judge's office. So we start on line 47. We go to shall do it. What I meant by that, they will, if you meet all the requirements set forth in our code, you will be given a license. If you look down there, someone asked me this morning on, line 48, on the investigation of the applicant pursuant to subsections B and D. B is when that probate judge looks on the application you get and sees an exception. That's in B. You've done something wrong. Well, he can prohibit you from having it. And D is where it talks about renewals. He can do the same thing. As we jump down, look on line 58. This is clarifying the 90 days before, 30 days after when they can get a renewal. Okay, on line 76, give credit, this is a definition and term, to Representative Coomer, who helped me with this on, we didn't really have a real clear, was thought, definition of armed forces. Representative Coomer, is the military, helped us with that, and that's really in this little section, on page 3 where it really talks about that. Just making sure, because remember, we won't allow folks who may have been honorably discharged, and now it says, like it says here on lines 91, a written letter, that they can get a permit so they can work in the security industry. And that is going to be, we felt, been very advantageous for them. I do want to call your attention to line 86. We had the word issued to or maintained by. Remember this, and when you are issued this permit, then, or license, you maintain it by your good behavior. If you do something that get 2 misdemeanor drug possessions, whatever, convictions, it can be revoked, and that's what comes up in just a few minutes. We go down to lines 105. This is where the biggest contentious part of it was fingerprints on renewals. And we'll just kind of take a minute as we look through that. We're saying that, once that you've got that fingerprint done by some probate judge in the state, that means you have a current license, like many of us do, that having that license says you've been fingerprinted. And so we got past that. We wanted to make sure that was just very clear. Let me get back online here. And now that when you do your renewal, you'll do a non-fingerprint based check. Very clear. If we look over on 118, it's just the same, just goes back, refers back to 105 to 115, clears up the language, no fingerprints at renewals. We look down here on 130, really talks about judges revoking licenses. We want to make sure and very clear that if you do something to get your license revoked, it is reported back to GCIC. They know about it. It's out there. And we do, as you'll see in a minute, we give the judges and courts the ability to notify the probate judge. because he's the one that does the revocation, and we want to make sure he does that and it's done in a timely manner. A good issue brought up today I'll need to address maybe is that also if your license is renewed or reinstated, that it's done in a timely manner. And I think that's something we'll probably have to try to address that maybe. As we go over there on 135, we're talking about our judges right there and just empowering them to ask. Lines 155, this is an ask by the probate judges. If someone wants to lose their license and notify them, they didn't want to have to call everybody, and there was no way to do this part of it that's in the law, so they wanted that struck. Look at 163. We're talking about law enforcement's access to records in the probate judge's office, which I think we all felt was appropriate. They should be able to do it. It gives them some follow-through. They have a very strict method in law enforcement of how they access needed law enforcement data from each other. It goes back to even on the license plate reader bill we heard earlier, where if someone's doing it just for pleasure to check on their girlfriend, that thing is found out. They look, and it really is enforced, and I like how that's done. That's why we put that in there for them. Look over on 177. We'll start in there. The ACCG and GMA both had a question. In House Bill 60, we really said clearly that we in the state of Georgia are going to be the ones in the legislature that's going to dictate how weapons are carried and all that, everything we did with that bill. One thing we did, we give counties and many other groups the ability to self-regulate. And one thing we hadn't thought of was in a county has unpaid volunteers who may be coaching recreation basketball or whatever, that at the county, because they're volunteer working for the county, they should be able to determine whether or not that individual should be able to carry a weapon or not. And so we're giving that power back to them. And then just on the very bottom there, we give on 197 the ability for probate judges to talk to one another. And that's something that was not in there. So we took a lot of time, committee, just to try to answer questions from, you can see it's kind of scattered around. It's kind of hitting this and that. And we're just trying to take what we did in 60, clear it up, and make sure we're on the right track. Mr. Chairman, I'd be glad to answer any questions.
Well done. All right. Committee members, here's a question. Thank y'all. Do we have anyone here that wishes to testify? I see some familiar faces out there. Yes, ma'am. If you would come up and identify yourself, and remember, brevity is of a value here.
Hello, how are you? Thank you, sir, and I certainly will be brief. Thank you all for hearing me. Kelly Persons with the League of Women Voters of Georgia. I know I'm not a usual face for this committee. We do a lot of elections work. The reason I'm here is actually about 5 lines, and I'm sorry I have an older version of it, so I will reference the lines that I have. If you all will look on line 7, it does say we understand why we are making this change, but my issue is actually that it specifically says code section of the election law should be the guiding principle in the poll location. And then we also have line F that gives a list of exceptions. If you all, and I'll read the election code so you all know exactly what it says. But the election code that it references, 212413, explicitly says, no person except peace officers regularly employed by the federal, state, county, or municipal government or certified security guards shall be permitted to carry a firearm within 150 feet of a polling place. Your provision following on line 29, which is F, actually has exceptions about 3 pages long of individuals who would be allowed to carry a weapon into a polling location. Some of these individuals would actually be listed on the ballot. So my question is, I'm not clear as to what law would reign. Would it be the election code that you guys are have listed on line 28, or would it be the exceptions under 1611-130? I just think there might be a way to clarify that. I think allowing potential candidates to carry a loaded weapon into a polling place could lead to a variety of different issues that I don't think counties or cities are quite prepared for. So if we could get some clarity as to what laws should be governing our polling places, I think that would be very helpful.
Julius, would you like to comment on this for the lady? No. No, I didn't think you did. All right. Mr. Jaspers?
I have no comment. That was not...
Would you like to hear the question again? Would you ask Julius the question again?
So the question I have, and sorry to put you guys on the spot, we are looking at line 27. It says on number 7 that it would basically go to the election code, so 21-413, which says regularly employed individuals as security could carry a weapon. Line F right down gives a variety of different exceptions in 1611-130, and it really is 3 pages long worth of exceptions. So my question would be, in the poll location, would these exceptions under 1611-130 be allowed to carry a weapon, or would we default back to the election code that you guys are referencing on 28? It's just very unclear to me as to who would be allowed to carry a weapon into a poll location, and we certainly don't want potential candidates on the ballot to be able to carry a weapon into a poll location.
I think if I understand the question, I think that the exemptions in 1611-130, those are the only folks who would be able to carry a firearm in a polling place, and that's it.
So those exceptions would affect the poll location. So a current district attorney would be able to carry a weapon into a poll location. A retired judge or a judge on the ballot would be able to carry a weapon into a poll location.
I mean, you're an attorney. I don't see it that way.
Okay.
So, of course I would. But,
or maybe if we can find a way to change it.
Is the election law, that federal law, I think we're referring to.
Okay. I probably need to take a look at that. Yeah. I think I need to take a look at that because the code section for the state exemptions may not impact upon federal election law, so that's something that
Because my question would be, if her statement is true, they would be able to do that today.
Mm-hmm.
And I'm not sure about that, quite honestly.
I think that she can, based on the election law. I mean, that's my. I'll be glad to ferret that out more, but I cannot, because that would be current law today. Because what's going on in 29 and 30 is just reinstating current law today. Is that not right?
Correct.
And so, knowing that, it should not change how anyone in 29 and 30 would affect in a polling place.
My main suggestion would be to exclude 7 from provision F. I'm not really sure how to do that or if that is the will of the committee to do, but I think if we can get some clarification as to whether the election code is the one that rules here or if it's these exceptions. And I'm not aware that these exceptions are currently in place, but again, they could be, and I'm just not aware of them. So.
Good. All right. Do you have anything else?
That was it.
All right. Would you highlight that, Mr. Jaspers?
Yes, sir.
All right. Now, do we have anyone else who... We have a constitutional friend from the back. Brevity.
Coming to you from Radio City.
No need in paraphrasing dead founding fathers, and we all agree. All right. You're probably sitting in probably the most pro-Second Amendment committee in Atlanta.
Chairman Powell, members of the House Public Safety and Homeland Security Committee, thank you again for allowing me to have this opportunity to address you. I'll keep my statements as concise and succinct as possible in the interest of brevity and time constraints. I support this legislative proposal, and I ask for your favorable consideration of it. All of Georgia's approximately 500,000 license holders deserve to have this issue clarified so that there is no differentiation on interpretation on what may or may not be allowed, and especially for our judicature. Thank you.
Hey, thank you so much. Mr. John Monroe, a legal scholar in his own mind. Have you looked at this on behalf of yourself and Georgia Carey?
Yes, we have.
Would you give us a succinct comment that everything is well in this bill? There is nothing unintended consequences that we don't know about?
Georgia Carey supports the bill, Mr. Chairman, and I would only comment, I was just speaking with Chairman Jaspers, I think the current law allows the people listed in 1611-130 to carry in polling places, and they would continue to be allowed to carry in polling places under the bill because the bill doesn't address that. So sheriffs, district attorneys, solicitors general, clerks of superior courts, all those people are elected officials, and they can carry firearms in polling locations today and still will be able to.
Very good. I might take just a minute to introduce my counterpart from the Senate. Mr. Chairman, would you like to come up and greet your counterparts over here on the House?
You're doing a phenomenal job. I appreciate the work you're doing, and I look forward to good legislation in America.
Trust me, we're sending you over a boatload of it this afternoon.
I'm sending you a boatload too.
Good deal. Good deal. Good to have you, Tyler. All right, ladies and gentlemen, any other questions from the committee members? Anyone else that wishes to comment on this bill? It's been anointed then. If I might make, before the chair entertains a motion on this bill, you would be sure to check on the lady's question.
Yes, sir.
And be prepared, if need be, to have a Rules Committee amendment of clarifying if need be. Very good. What's the pleasure of the committee?
Do pass.
We have a motion do pass as a committee substitute. We have a second. Any other questions? Any comments? All in favor say aye.
Aye.
Opposed? The ayes clearly have it. Good job, Rick. All right. All right, we are down now. We're back to two bills. Mr. Nimmer, are you ready?
May I approach you, Mr. Chairman, ask you a quick question?
You don't have to approach. I'm not a judge.
Just ask you.
Read everything. After comma, by the payment of a fee as established by the council, any such person may request. Revolver firearms, payment of a single fee, provided that such person requests a semi-automatic and revolver firearm notation at the same time with his or her request. You and I both have worked with one, and I think you know the one I'm talking about. Julie, this is wonderful.
Okay. All right, sir. Appreciate all your help. No problem.
You may want to come over and help me.
Yeah, if you want me to read since my handwriting, that's fine. I can just pass back or in 20, 30 minutes.
Yeah, you read that. I'm going to say, Julius has me, he will read the amendment.
Okay.
All right, Mr. Nimmer. Julius, do you have some language?
I do. You want me to offer it from here, Mr. Chairman, or you want?
Would you rather for Julius to offer it?
Absolutely, yes, sir.
I always try to look after my friends, and sometimes I found it's easier to get the lawyers that write it to offer it. All right, ladies and gentlemen, we have back into our. All right, what was that bill number?
421, Mr. Chairman.
All right, 421.
Yes, sir.
All right, we're back at 421. We have an amended version. Julius, would you like to?
Sure. Can I have my copy back? I'm sorry. Thank you. Thank you. Okay. The amendments that we have are on lines 13 through 15, where we're going to replace that by saying conservation ranger under code section 27-1-17, comma, any peace officer certified pursuant to Chapter 8 of Title 35 and employed by the State Board of Pardons and Paroles, comma, and any peace officer certified pursuant to Chapter 8 of Title 35 and employed by the Department of Corrections, comma, and any community supervision officer employed by the Department of Community Supervision.
All right.
And then for lines 33 through 36, we'll read as a deputy conservation ranger under code section 27-1-17, comma, any peace officer certified pursuant to Chapter 8 of Title 35 and employed by the State Board of Pardons and Paroles, or any peace officer certified pursuant to Chapter 8 of Title 35 and employed by the Department of Corrections, comma, or any community supervision officer employed by the Department of Community Supervision.
All right.
That's fine. And then lines 42 through 43, we'll read, he or she had continued in service as a deputy conservation ranger, a peace officer certified pursuant to Chapter 8 of Title 35, and an employee of the Department of Corrections, comma, a peace officer certified pursuant to Chapter 8 of Title 35, and an employee of the State Board of Pardons and Parole, comma, or a community supervision officer until his or her mandatory retirement age, period. And that's it.
Thank you, Mr. Chairman. Julius, thank you for clarifying the language in the amendment. And
All right.
yes, sir.
Joe?
I've got a question, Mr. Chairman. My understanding is peace officer is a much broader definition. That's not what my understanding is that's not what current law is for parole officer and probation officer. If you go to peace officer, there's a different definition. I believe that's going to widen who you're covering. I'm not suggesting that I don't know if that's your intent or not, but that's wider than what we cover today, to my understanding, when we were drafting 310.
No, the intent's not to answer the question. It's not to widen who is currently covered. It's to make sure we don't lose who we are currently covering.
If I might make a suggestion, is there any way why don't we just not strike parole officer, probation officer that's in the current bill? Would that accomplish what we're after?
Let me make a recommendation, because I'm a little bit familiar with what this is behind. This is a companion bill to the Governor's Criminal Justice Reform Bill 310. It creates the Department of Community-Based Supervision. And what we're trying to do is be sure that we know that for 2 years there's going to be employees from both pardon paroles and from corrections that's going to have to be technically, administratively attached and working for this new division. We want to be sure that these people, if they're injured in the line of duty, that these people will still be eligible for their disability and for the pay that they would be normally due. Now, if I might, just to be sure that we're perfecting what's coming out of here, I'm going to hold at the discretion of the chair, I'm going to hold this bill for the night.
Okay.
And I'm going to give y'all time to Joe, if y'all would, at OPB, and get with the governor's folks and work with Julius, get the proper terminology. And I will call a meeting, a special meeting, either tomorrow or either Thursday morning, and move this bill forward. For the knowledge of the committee, when you see that yellow sheet attached to it, that's an audit sheet. That means that this bill is going to have to be, what we are going to pass here is what the Department of Audit's going to be looking at. They'll be looking to that verbiage so that they'll come up with an actuarial price, if there is, so we know what we'll be voting on next year. So it's a 2-year process on that. But we still have to pass a bill out that has the verbiage in there so they'll know what kind of actuarial process they're doing. So would that be all right with you?
Yeah, Mr. Chairman, thank you. I appreciate that time and the.
And if y'all could let me do just as soon as y'all get the substitute ready, and we can do this, we can call a committee meeting 8 o'clock Thursday morning, or we can call it sometime tomorrow, whenever, so we can move this bill forward.
Yes, sir. I'll get it right.
All right.
Thank you.
Thank you so much.
Thank you, members.
Last but not least, Mr. Gravely, you got your language?
Yes, sir, Mr. Chairman.
494, we're back.
494. To summarize, Mr. Chairman, what we're doing is we're giving law enforcement, retired law enforcement personnel, the opportunity to save $25 should they choose to qualify with their revolver and their semi-automatic at the same time and send that paperwork in, while also adhering to, or at least acknowledging, the cost to post to produce the card. Julius has got the language that I think all parties have agreed on. And Mr. Julius, thank you for your help on this. If you would like to carry, we're going to be looking on line 14, Enforcement Officer Safety Act of 2004, Public Law 108-227, comma, I believe that's what Julius is going to pick up.
Correct. What we're going to do is insert after
108-227, comma, and this language will be will follow after that. So, comma, by the payment of a fee as established by the council, any such person may request that such card evidence the ability to carry a semi-automatic and revolver firearm by the payment of a single fee, provided that such person requests a semi-automatic and revolver firearm notation at the time of his or her request.
Sound good to you?
Mr. Chairman, sounds good.
Sound good to any of the committee? We've got 2 old hand jobs down there. How about you 2 guys?
Appreciate the bill. It's good. Mr. Chairman, could you?
How about you, Bill Hitchens? How about you, Alex Atwood?
Yes, sir.
Julius, could you read that one more time?
Sure. This is the language I'm about to read goes after 108-227 on line 14. So after the comma, this language will follow. By the payment of a fee as established by the council, any such person may request that such card evidence the ability to carry a semi-automatic and revolver firearm by the payment of a single fee, provided that such person requests a semi-automatic and revolver firearm notation at the time of his or her request.
Alex? We got 3 retired law enforcement officers down there. Am I seeing all of them shaking their hands and holding hands and singing Kumbaya together? All right, what's the pleasure of this committee? As a committee substitute. All right. Do we have a motion and a second? Do we have any other questions from anyone? All in favor say aye. Aye. The ayes have it. I'll be notifying y'all on short notice probably to do Mr. Nimmer's bill, the governor's bill. I want to thank you all for your tolerance today and being here. All right, baby. Me and you run late.